the National Crime Victim Law Institute presents Understanding Victims' Rights Law for Advocates. Why understanding the law matters. Victim advocates serve many critical roles. Key among these is serving as a vital source of information during times when many victims can feel overwhelmed or uncertain. In addition to offering a wealth of information about local resources and referral partners, advocates provide crucial information about a jurisdiction's victims' rights laws. For many victims, advocates may be the first, or sometimes the only, source of information about their rights. This is why understanding how to read laws is so important. An overview. In this short video, we will discuss a few key points: where rights can be found in the law and why that might matter, where words are defined in the law and why those definitions can be important, the use of expansive language and examples in victims' rights laws, the difference between automatic and requested rights, and the difference between mandatory and permissive rights. Where in the law victims' rights can be found and why this matters. Victims' rights can be found in many different places in a jurisdiction's laws. In some jurisdictions, a victims' rights amendment has added victims' rights to the state constitution. Generally speaking, when thinking of law as a hierarchy, constitutional rights are the most powerful and take priority over rights incorporated elsewhere in law, such as in statutes or rules. Well over half the states in the United States have enacted constitutional rights that are specific to victims of crime, and these are often part of a victims' rights amendment in the state constitution. Below constitutional rights in the hierarchy of rights are statutory rights. Every jurisdiction in the United States has guaranteed victims of crime statutory victims' rights, and these can be found in many different areas throughout a jurisdiction's code. Beneath statutory rights are rule-based rights. These rights often reiterate rights that also exist in either a constitution or statute, but they can occasionally provide standalone rights as well. Victims' rights at all levels of the law are important and help facilitate victim voice and choice in the justice process. Knowing whether a particular victim's right exists in a constitution, statute, or rule becomes important in cases where an assertion is being made that a victim's right conflicts with a right of another justice participant. It is also important to keep in mind that victims have rights beyond the ones that are labeled victims' rights. Crime victims don't give up rights that apply more broadly just because they're the victim of a crime. There are federal constitutional rights that apply to everyone in the United States, for example. Many state constitutions also have separate rights, such as rights to privacy, that are not victim-specific, but which may nevertheless be important to victims of crime. Definitions are key to understanding victims' rights. When it comes to identifying who qualifies as a crime victim entitled to assert a particular right, definitions matter. It might seem like it should be easy to determine whether someone is a victim of a crime, but this can be tricky because legal definitions of words can be different from the ways in which we use words in everyday life. Because legal definitions are precise, a person may meet the legal definition of crime victim in one jurisdiction but not another, even with an identical set of facts. Similarly, crime victim may be defined differently in different parts of a jurisdiction's code. For example, a person who meets the legal definition of crime victim for purposes of seeking restitution from a convicted person may not meet the legal definition of crime victim for purposes of another right in the same jurisdiction. To understand if someone qualifies as a legal crime victim who is entitled to rights and can assert and seek enforcement of those, it is necessary to carefully read these legal definitions. Expansive language and examples. Sometimes the language used in laws is expansive, creating greater access to rights and options for victims. An example of this is when a jurisdiction uses the words and or any when defining who may qualify as a crime victim. Many jurisdictions incorporate definitions of victim that allow for multiple individuals to potentially qualify as victims of crime who are entitled to assert or seek enforcement of rights in at least some circumstances. In Oregon's Constitution, for example, victim means any person determined by the prosecuting attorney or the court to have suffered direct financial, psychological, or physical harm as a result of a crime, and, in the case of a victim who is a minor, the legal guardian of the minor. Another example of expansive language can be found in Iowa's law, which specifies that victims of crime may present a victim impact statement to the court using one or more of the specified methods: filing a signed victim impact statement with the county attorney, orally presenting a victim impact statement, making a video recorded statement, making a statement remotely using video technology, making an audio recorded statement, appearing by speakerphone to make a statement, or having the victim's attorney or other designated representative give a statement on behalf of the victim. This law provides victims with a number of options from which they can choose, along with explicit language clarifying that they may choose more than one option. Sometimes the law uses language that provides examples or guidance relating to the exercise of victims' rights without imposing any restrictions on the rights themselves. In these cases, the law may use words such as including, for example, or including but not limited to, followed by a listing of specific examples. It is common for restitution provisions to include this type of language, listing examples of specific types of losses that are eligible for restitution, such as medical expenses, mental health expenses, lost wages, or the cost of repairing or replacing property. When the law provides this type of guidance, this does not prohibit other losses from being sought in restitution as well. Automatic versus requested rights. There are two common types of victims' rights: automatic rights and requested rights. Automatic rights are those that apply without needing the victim to take any kind of action. They are entitled to those rights automatically. Requested rights, on the other hand, apply only once the victim takes some kind of action, such as requesting the right either orally or in writing. An example of a requested right can be found in Florida's Constitution. In Florida's Constitution, victims have the right, upon request, to receive a copy of any pre-sentence report and any other report or record relevant to the exercise of a victim's right, except for such portions made confidential or exempt by law. This right is a requested right because it requires the victim to specifically request the information rather than it being automatically provided. Victims need to receive timely information about all of their rights, whether those rights are automatic or requested, and when rights require victims to take specific steps to activate those rights, they need to know how, when, and to whom those requests can be made. Mandatory versus permissive rights. Victims' rights may be worded in a way that makes them either mandatory or permissive. Mandatory rights must be afforded to victims. Permissive rights give an individual discretion to decide whether or to what extent a right will be afforded. Mandatory rights often use the words shall or must, or are phrased as statements without qualification, while discretionary rights often use the word may, or are phrased in a way that makes clear that the rights are subject to a system actor's discretion or judgment. Even with discretionary rights, there are legal limits that define how a system actor can exercise their discretion. For example, discretion cannot be exercised in a discriminatory way. An example of a mandatory right can be found in Ohio's statutes. In Ohio law, the court shall permit the victim to be accompanied by an individual to provide support to the victim, a victim advocate, and a victim representative. An example of a discretionary right can be found in Indiana's statutes. In Indiana, the law specifies that, in addition to any sentence imposed for a felony or misdemeanor, the court may, as a condition of probation or without placing the person on probation, order the person to make restitution to the victim of the crime, the victim's estate, or the family of the victim who is deceased. Knowing whether a right is mandatory or permissive is often important for victims, as it can help establish expectations about what they can expect when asserting or seeking enforcement of their rights. The role of a victim's rights attorney and referrals. Understanding how to read victims' rights laws is important for victim advocates so that they can assist with developing and providing accurate and helpful information to survivors about their rights. Of course, victim advocates cannot give legal advice, so it is important to know referral sources in your jurisdiction to attorneys who can offer this service. The National Crime Victim Law Institute is committed to expanding the field of attorneys who provide victims' rights representation. We train and provide technical assistance to attorneys nationwide who are interested in adding victims' rights representation to their legal practices. NCVLI can also help pair victims with no-cost attorneys through the pairing portal on the website of our membership organization, the National Alliance of Victims' Rights Attorneys and Advocates, NAVRA. If you would like to continue learning more about victims' rights and the role of victims' rights attorneys, please visit www.ncvli.org.